Straight ahead on Law and Crime Daily. Derek Chauvin makes his first federal court appearance following his conviction for the murder of George Floyd. Why the former cop is now in isolation behind bars. Sean Larkin joins us to talk about his new book on wrongfully accused cops and to share his own story about his time on the Tulsa Police Force. Plus, a sneak preview into the latest show about criminal trials Court Cam presents Under Oath.
This is really telling you how we got there, as well as the defendant's decision to take the stand.
And will a shocking jailhouse call come in as evidence in the Tennessee trial of a father accused of murdering his 5-year-old son?
I'm not telling the whole story either yet.
Plus, a retired NYPD detective defends his investigation into the still unsolved disappearance of the wife of a millionaire real estate heir. The testimony in the Robert Durst trial.
What hard evidence? What crime scene? What dead body?
Law and Crime Daily, covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmeyer along with Terri Austin. Former Minneapolis police officer Derek Chauvin makes his first appearance in federal court and says he can't afford to hire a lawyer. Law and Crime's Angenette Levy is here with what happened at Chauvin's hearing.
Yeah, Brian, Derek Chauvin will remain behind bars until his trial on federal civil rights charges. He didn't contest his detention, referring to what he called his current circumstances.
The last time we saw Derek Chauvin, sheriff's deputies led him out of the courtroom in handcuffs after he was found guilty of unintentional murder in George Floyd's death. As he sits in prison in isolation, Chauvin is now accused of violating Floyd's rights and the rights of a 14-year-old boy.
If the police officer knew what the constitutional rights were and acted excessively anyway, that's the crime that is charged in this case.
Former U.S. Attorney Ben Glassman explained the basis for the charge. Chauvin was a police officer when he kneeled on George Floyd's neck. He's also accused of hitting a 14-year-old boy in the head with a flashlight during a domestic violence call and kneeling on him, too. Eric Nelson, the defense attorney who represented Chauvin at his trial on state charges, has been appointed by the federal court to represent Chauvin because he claims he's indigent.
The fact he's not working now and presumably going to prison pretty much makes almost anybody indigent.
Defense attorney Jay Clark says Derek Chauvin had to present information to the court about his finances to be declared indigent and have taxpayers pay Nelson to represent him.
It makes sense. He knows the case better than anybody at the time could know, which means the case can be prepared and move along faster.
Now, the Minnesota Police and Peace Officers Association paid for Chauvin's legal bills in his state case. I contacted that organization, and a spokesperson told me that she had no comment when I asked why the organization wasn't paying for his representation in the federal case as well. Brian?
Thanks, Angenette. Joining us today is Sean Larkin, retired Tulsa Police Sergeant and host of the podcast Cocktails, along with Terri Austin. Sean, back and forth from state to federal courts, what do you imagine transporting an officer convicted of murder like this is like?
It's going to be uncomfortable for the officers, the deputies, the marshals, everybody involved. I myself was involved in an arrest here in Tulsa several years ago where we actually had to arrest an officer on duty. And just that alone is so uncomfortable. Chauvin is, in a negative way, I guess, probably the most well-known police officer in the country, at least right now. And so for everybody involved in that transportation, they understand that they are going to be under scrutiny. They're going to be watched. It's going to be on the cameras. And it's just going through the motion for these guys.
Yeah, let's hope they're definitely safe and no one's targeting them there. Don't want that to happen, of course. Terri, Eric Nelson does know a lot about the case, but could it be better to have another pair of eyes on this case as we go to another step in the trial?
Listen, I would want someone who knows the case inside and out. But in a perfect world, a defendant would have someone who knows the case plus someone who has a fresh pair of eyes. But a right to a fair trial definitely does not include unlimited funding for representation.
Now, Angenette, we do provide criminal defense for individuals if they can't afford it, myself being a public defender. But do you know how much defending a case like this could cost in federal court?
I asked around, and say that Derek Chauvin had unlimited funds and he could pay for a lawyer. I talked to Jay Clark about this, for instance, and he said that this defense in federal court would cost at least six figures. He guessed that a retainer alone would be $250,000. And he said, well, think about it. Even if it was $100,000, that's still a lot of money for somebody to come up with. So it would be incredibly expensive, he said, just because of the amount of work that goes into it and the high profile nature of the case.
Yeah. That, of course, would be for someone to retain. If there was a defense attorney, maybe probably much less. I know that CJA, or the federal panel, pays about $150, $190, depending on if it's capital or non-capital. So we'll keep eyes on that. Now, don't go anywhere, Sean, because I know you have a new book coming out about your experience as a law enforcement officer. Breaking Blue tells real stories of cops accused of wrongdoing and subsequently cleared. Larkin even shares his own story. Breaking Blue will be released on June 15th and is available for pre-order now. Sticks, I've got to ask, let's get right to it. Tell us about when you were wrongfully accused.
Oh, well, unfortunately, there's several different incidents, some small in size, some much larger. But the one I focus on here in the book started in 2009. There was a federal investigation of the Tulsa Police Department for a couple different groups of officers. And this thing just, in my opinion, it steamrolled and got out of control. Pretty soon you had bad guys that were essentially being told by the FBI that was doing the investigation that, hey, if you've got information on dirty cops, we can help you out with we can help you out with your case. If they were already locked up, hey, we can get you out of jail. Then people started filing civil lawsuits, and it just started building up over a year time period. And there were a handful of different officers whose names got brought up. Some, in fact, did get arrested and go to trial. Luckily for myself, I did not. But I was labeled as what they call an unindicted co-conspirator. And still, something still to this day that if you Google my name, it occasionally pop up. And throughout my career, I've had to deal with that title and fighting it every step of the way in court.
Well, let me put it this way, Sean. I would say it's not unlucky or luck. It's innocence. It's obviously there's a reason why you weren't arrested for that. Now, in this collection of stories, is there one from someone else that stuck out to you even now as you think back on your book?
Yeah, absolutely. You know, I was fortunate to talk with several different officers across the country, and these things range from a simple traffic stop to, you know, a guy who spent time in prison for a murder he didn't commit. But one of them was a guy by the name of Clyde Ray Spencer. It actually took place in the 1980s. He was arrested and convicted for child molestation of his own kids when they were very, very little. And he spent a little over 20 years in prison. And over that time, it finally came out that his ex-wife was having a sexual affair with the supervisor over the investigating unit. DNA evidence, or what we call a SANE exam, a sexual assault exam, that was never turned in. It was held in a detective's garage for nearly 20 years and later magically appeared. That would have cleared him probably during trial. So this poor guy spent, you know, I think it was a total like 21 years in prison for a crime he never committed.
Thank you for that, Sean. Make sure to check out Sean Larkin's book, which is available now for pre-order, but of course is coming out on June 15th. Still ahead on Law and Crime Daily, we take you inside the courtroom of two live trials we're following gavel to gavel. But first, a sneak peek into the latest show featuring defendants taking the stand, our interview with Dan Abrams after the break. We're back. A new series premiering on A&E is all about the courtroom drama we often see at Law and Crime. We spoke with executive producer and host Dan Abrams, who's also the founder of Law and Crime Network, to give an exclusive sneak preview. Let's take a look at Court Cam Presents Under Oath.
It is incredibly rare for criminal defendants to take the stand.
Real suspects accused of murder.
It's a high-stakes gamble. Very few take.
Delivering real testimony in their own defense.
You acquire the knife and the zip ties.
Never leave home without them.
Will they stand the pressure or fold under oath?
You put the gun bitches from his head.
Looks like extreme planning.
It was an accident.
An A&E original series, Under Oath. Wednesday, June 2nd at 10, only on A&E.
Dan, thanks for being with us.
Good to be with you, Brian.
Pleasure. Now, Dan, what can we expect when we tune into the back-to-back premiere of Under Oath?
This is a show about defendants who take the witness stand in murder trials. And as you know, as well as anyone, it is very rare for a criminal defendant, much less a murder defendant, to take the stand in his or her own defense. It is an enormous risk. The whole case comes down to, does the jury believe this person's testimony? And so in each one of these episodes, we show you what led to that decision, why the person has decided to risk it all by taking the stand, and then showing you much of that person's testimony, but also interviewing some of the people who were there at the time to give us insight into what it was like inside the courtroom, the decision to have the defendant take the witness stand, et cetera. So it's a high stakes gamble. And in each and every episode, we show you that defendant on the witness stand.
Sounds like you basically took most defense attorneys' anxieties and put it into a TV show. It's going to be great. Now, the interesting part about this, Dan, is Under Oath is from the unique lens of the accused as you take them through the case when they take the stand. Talk to us about the angle or the perspective of this story.
Yeah, so what we try and do is not just say, oh, here's the defendant who took the witness stand and here's the video of it. What we try and do is explain the circumstances surrounding it and why the person decided to take the witness stand. We'll talk to, very often, their lawyer. Sometimes, by the way, we interview the defendant, him or herself, about exactly why that chance was taken, why they decided to risk it all, and then show you, of course, what is the biggest part of this, and you pointed this out as a criminal defense lawyer, the cross-examination, right? That moment, everything seems okay. The direct examination comes through. Oh, you see why they took the stand. They want to tell their story, okay. But it all comes down to the cross-examination, which is the most difficult part for any defendant, particularly when you get a good, tough prosecutor asking the question.
Absolutely. Prosecutions always coming tough with those cross-examinations because they very rarely get to defend it on the stand, so they enjoy it when they do. Now, Law and Crime viewers should recognize some of the cases that you cover on Under Oath, right?
Absolutely. You'll see, look, some cases that people will remember, like the Jodi Arias case, for example. But then you're going to see other cases, like two of the cases that I think were the most interesting, both of which were Law and Crime stories, were the Tammy Moore case and the Lindsey Parton case. Both cases of women, Tammy Moore accused of killing her husband's girlfriend, and in the case of Lindsey Parton, a babysitter accused of killing a 3-year-old girl. In both of those cases, one of the reasons I found these to be the most interesting cases was because it was unclear whether they did it. And there was a real question about, well, wouldn't they not take the stand? Tammy Moore sits up there and tells you everything that she says happened. So those are the cases I found to be the most interesting, were the ones where it was really close. And the defendant's testimony really made you say, I wonder, is this person guilty or not?
Court Camp presents Under Oath airs Wednesday on A&E at 10 p.m. Coming up on Law and Crime Daily, defensive testimony from a former police detective in the disappearance of Robert Durst's first wife. Plus, jury selection now wrapped up in a trial of a Tennessee father accused of murdering his 5-year-old son, what the jurors will and won't hear at trial next. Welcome back. A jury is now seated in the upcoming Tennessee trial of a father accused of murdering his son and hiding the body.
And my son has escaped, we cannot find him.
Okay, how old is your son, sir?
He is 5.
3 days after Joseph Daniels called to report his 5-year-old son with autism as missing, police arrested Daniels for murder. The Tennessee Bureau of Investigation said Daniels confessed during a 5-hour interrogation to hitting Joe Clyde Daniels to make him stop crying.
Yes, sir. He said he said that Joe Clyde was bleeding a scratch on his leg and inquired further what that was from. And Mr. Daniels said it was from the coffee table.
But the defense says Daniels suffers from mental health issues and gave a false confession. They say police didn't thoroughly investigate as the boy's body has never been found. At a pretrial hearing, the defense suggested the boy could have been abducted. They called a local woman who said their then 4-year-old daughter spotted a boy in her grandmother's yard. The woman says her father lives there and is a registered sex offender. The woman says her daughter told her she asked the boy for his name, but he instead said he was 5 years old.
that she saw a little boy walking down the road in pajamas, and he was talking to her for a minute and then just kept walking.
Lauren says she filed a police report, but investigators never did a thorough search of the property. The judge ruled the police report can't come in at trial due to hearsay, unless the little girl, who's now 8 years old, testifies. And at another pretrial hearing, prosecutors played a phone call the defendant made to his father from jail.
Too late. I pushed her off.
The defendant can be heard saying that Crystal Daniels, his wife, and the boy's mother killed their son with a pillow. Daniels says she threatened to kill him if he told the truth.
As long as Phil was basically motionless, completely motionless. Then I pushed her off from time. He was gone. It was just like, she didn't go to the kitchen, pulled a knife. She runs to me and says, "If you actually anybody that told you that did this, I'll kill you or have you killed by somebody."
Crystal Daniels is charged with aggravated child neglect or endangerment and helping to cover up the crime. She'll face a separate trial, and her attorney has said she'll plead the fifth if called to testify in Daniels' trial. All right, Terry, let's dive into these pretrial arguments. On one hand, the defense sounds geared to put an 8-year-old on the stand to point out to a completely different suspect. Could that create reasonable doubt for the defense here?
It could, Brian, but I really think the defense is stretching this argument here. First of all, it was a 4-year-old child at the time, and she's going to come in now a few years later stating that it could have been someone else, or the whole point here is that the father, who was apparently in a home there, is a sex offender, and that didn't come to light. And so the defense wants to show that had the police investigated further, that they would have been able to determine that information. But this 4-year-old child is not going to be able to remember what occurred, and her mother at the hearing even said as much.
All right, we'll see. On the other side, if the child did see Baby Joe, then how could Daniel's jailhouse call make sense? What do you think the defense will do at trial? Try one or the other?
You know, the call, I think, was really the defendant trying to set up his wife, Crystal, because it was just too convenient. The father was basically asking the son, who's the defendant, whether or not he did it. And the defendant is basically saying, no, Crystal did it. I tried to stop her. So I think at trial, we are going to see the husband and wife pointing at each other.
Absolutely. It's probably the main reason why the two cases are separated. The husband's going first, the wife's going afterwards. We'll see how this plays out for the prosecution and the defense. When we come back, the NYPD detective standing by his investigation into the disappearance of missing woman Kathy Durst. Why it's being called into question decades later at a different murder trial next. Welcome back. Prosecutors in California say the disappearance of a millionaire's wife decades ago is the motive for the murder of Robert Durst's best friend. Robert Durst is standing trial for the December 2000 murder of crime writer Susan Berman. Investigators believe Berman had information about the still unsolved disappearance of Kathy Durst in New York 1982, and say Durst shot her because she threatened to go to the police. Durst denies killing either woman. The NYPD detective who investigated Kathy's disappearance was called to review his original case file. Michael Struck is now retired, but has admitted on the stand in 2017 to having sex with one of the witnesses in Kathy's case. That recorded testimony was played for the jury, so Struck didn't have to fly across the country for the trial.
The headline, lawsuit claims NYPD covered up Durst's role in wife's death. The Jews do anything to cover up Durst's role, if there was one, in his wife's disappearance or presumed death. Silly. I want to give you an opportunity to answer that here in open court and on the record. Did you do your death level best in your investigation? Yes.
Prosecutors then asked the detective about his first interview with Robert Durst after he reported Kathy was missing. The detective says Durst brought a copy of a magazine showing a photo of his father, Seymour Durst, the real estate mogul.
I wasn't impressed by it. Meant nothing to me. The name meant nothing to me. Who he was and his family.
fact that he had a magazine and I recall part of it.
Did you take it at the time as him basically trying to throw his weight around?
If that was his intent to impress me, it didn't work.
Kind of, if you knew what you knew now, are there many things that you would have done differently?
Of course.
Back with us is co-host Terri Austin. Terri, the prosecution is trying to strengthen their claim that Durst had something to do with Cassie's disappearance. Was this retired NYPD officer's testimony solid, or did the defense poke any holes?
You know, I think actually, Brian, that they did poke some holes in the prosecution's argument. Look, they're trying to say that not one body in the law enforcement arena thoroughly investigated. They're saying that the state handed it over to the city and no one pursued the leads and everyone dropped the baton. Everyone actually believed Durst when he said he dropped Kathy at the train station. So they were all looking for that lead. And so I definitely think that the defense poked some holes in the prosecution's argument there, because they should have followed up with the prime suspect, who is Robert Durst. Always you look at the individual closest to the victim, and they did not do that here.
Absolutely. Now, Terri, words are a part of the testimony, probably a really big part. But how did the officer come off to the jury? He was there when they tried to find Kathy Durst's real killer, but basically they're saying that he messed up in the past. So how did he take that?
You know, I think he was credible. I think the jury probably liked him, even though they're watching this over a video at this point in time, because he has no bias. He has no reason to lie. But he failed to follow up some good leads. So that's a problem.
Absolutely. Terri, thank you. And thank you for joining us here at Law and Crime Daily. We'll see you next time as we discuss justice in America.